towards lowering the amount of force needed and improving accountability. As a result, the city has budgeted roughly $5 million per year over 5 years, totaling over $25 million, but never engaged in a public dialogue about where that money should best be spent.
The thing about this particular slide is that it's a little bit out of focus because it's probably a sheet of paper that was literally stapled to the back of the agreement when the city council was deciding whether or not to approve the agreement, and it was labeled draft. You can sort of see in that corner is draft. So I think we thought it was just a suggested guideline and we would get back to it later, but there was never a community hearing of any kind about is this the right way to spend the money. And it's hard to read, but in the top part, we have 25 full-time employees for the Portland Police. And on the bottom part, you have 6, is that right? 6 employees for other. So this was a decision that was made, again, with no community input. And we're not sure that that's necessarily what's going to fix the problems that are described in the complaint that's in front of the court. Next, the agreement calls for the Independent Police Review Division, that's who we file their complaints with, and they take it in, that they should be able to conduct meaningful independent investigations. But it doesn't say what kind of cases that the IPR should handle. And there's been numerous reports, including an expert who came in from outside in 2008 that said they should have a list of what kinds of cases the IPR might investigate. So just again to back up a little bit, if you have a flow chart, when you file a complaint to the IPR, which is part of the auditor's office, and there's non-police employees, right? They take your complaint, they listen to what you say, and then if they decide to do a full investigation, they turn it over to the Police Bureau's Internal Affairs Division to do the investigation. And, as a member of Copwatch, when I tell people that, they call our incident report line and say, oh, so I can file this independent agency. That's great. And we say, then they turn it over to the police. People go, oh. Why would I want a police officer investigating my police complaint? There's only 10% of all cases that come in the door get investigated. The rest of them either get dismissed or handled as what's called a service improvement opportunity. But that said, the IPR, as part of this $26 million, has hired some new investigators. But the only time the IPR has ever done an independent investigation so far has been about a supervisor who mistreated a subordinate. So it's an internal complaint, not a community. There's no community member involved. So we thought it would be good to have a list of what that is. And moreover, it says meaningful independent investigations. Previously to this month, if they were going to do an independent investigation, in order to compel the officer to talk to them, the IPR had to have internal affairs sitting in the room with them. And when they wanted to ask a question, they had to say, okay, Mr. Internal Affairs, please direct that officer to answer my question. What's changed is that now they're going to have somebody from the Bureau, it doesn't have to be from Internal Affairs, in the room. They say, I generally warn you that you have to answer all the questions from this IPR person. So it really hasn't changed the fact that the IPR is dependent on the police to conduct these independent investigations. So who is deciding what's meaningful independent investigation is another question.
And lastly, the agreement does not call for mandatory drug testing of officers after deadly force incidences or incidents in which force leads to hospitalization. And that's unlike any other sort of profession I can imagine.
Right. So this is something else we wanted to see put into the union contract. Loosely speaking, the Portland Police Association contract that was signed last month in December. And so this is the drug testing policy as it exists, and basically it's random drug testing, which can screen out officers who are using drugs on a regular basis. But like Reverend Moore said, if you were a forklift operator and you dropped a huge load of stuff, they're going to say, "Go pee in this cup." If you're a police officer and you shoot somebody, it's a very unusual thing. And police officers don't shoot. I know it seems that way sometimes, but they don't shoot people that often. They're not going to get it.
Now, at this point, I think I'd like to ask Joanne.
First, we're going to do the next steps.
Okay.
And then we're going to do questions.
You advise. Okay.
So the next step, broadly speaking, 18th, it's a Tuesday. It's 9 a.m., it's at the federal courthouse down here in Southwest 3rd. And there is airport-like security, so you have to have your ID, photo ID, and you have to have go through a metal detector, so just so you know, if you're planning to attend. Do you want to talk about the COC? Okay, so the job description went up just yesterday for the compliance officer community liaison that we were talking about. And there's a lot of background that these job description suggests that the person who applies for this job has. It doesn't have to be a person with experience in law enforcement per se, but they just want to make sure that they understand what all the ins and outs are, like a lot of these things we're talking about. And so the deadline to apply for that is late February. We didn't know the exact deadline when we wrote this. So, and then in mid-March, so the fairness hearing is going to happen in February, and then in mid-March, and this is really the important one. There was a lawyer at the last one who asked a question about this, so maybe it's the lawyer who now you know the question. But the judge apparently cannot say, "Oh wow, community, look, you told me all these things that I don't like, that you don't like about this thing, so I'm going to tell them to change this because it's not fair, adequate, or reasonable in those places." Either he's going to say the whole thing is fair, adequate, and reasonable, or the whole thing's not fair, adequate, and reasonable. Given that, I think I don't want to disparage or discourage people who feel that they would like to testify, because I think the basic number one thing that we can get out of this fairness hearing, if nothing else, is explaining to the judge what we as a community think it will look like when the city is in compliance with this agreement. Understand what I'm saying? So that the words are kind of vague. We just spent like almost an hour telling you how the words that are in the agreement are kind of vague and you can interpret it in different ways. But if we lay out for the judge, this is what we expect at the end of 5 years, he'll have something on the court record that he can refer back to and say, well, you know, I think the community's expecting more of it. So that's one thing. The other thing is I already described that for instance, that December 31 deadline for figuring out how to collect data has been missed. There's also another deadline. The city was supposed to have created a walk-in center for people with mental illnesses, which is a key. The reason we're here is because people with mental illness are mistreated by the police. The city did not do that yet. It was supposed to be done by last summer. I will continue this train of thought after I get the next two things. So the COCL, the Compliance Officer Community Liaison, will be chosen from a pool of 3 finalists that are going to be presented to the community. So we're going to have input into who that's going to be sometime in June. And once that person's hired, they're going to appoint what's called the Community Oversight Advisory Board. 5 members will be selected by City Council, 5 by the Human Rights Commission and the Commission on Disabilities. 5 members will be selected by a process to be determined that the AMA Coalition is going to have input on, and that's the point I want to come back to, and 5 police advisory members who won't have a vote. And the reason it's really important that the community process exists, among other than it's much better than what's written in the agreement, is that the collaborative agreement between the DOJ and the AMA Coalition changed that paragraph. Instead of saying that there's going to be a citywide vote on who those 5 members are going to be, which is what it says in the agreement, now it says, now this collaborative agreement says that the DOJ and the AMA Coalition and the city are going to work out a different process. So, in other words, the agreement is not written in stone. So it is possible. There's a paragraph in the agreement itself, called paragraph 187, that says the city can change parts of this agreement if they just bring it up at City Council. So it is possible to change the agreement. So it's possible that the judge can give guidance to the city about changing the agreement, because there's all these things that already need to be changed in order for it to be accurate.